Welcome and thank you for joining Seyfarth's webinar, Deeper Dive into the CFPB Taskforce Report Recommendations. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, the attendee verification code will be read during the presentation. Please write down this code. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Patrick Kennedy. Patrick, you may begin.
Okay, welcome. I think we have a legal disclaimer that we need to, as a preliminary, get through. Now that we've had that legal disclaimer, welcome to Seyfarth Shaw's second in its series of Consumer Financial Services Practice Group's monthly webinars during 2021 on timely subjects in the consumer financial services area. This follows our first webinar held in February on the predictions for changes in the Biden-Harris administration and the CFPB's plans, with the new administration. In the upcoming months ahead, we're going to have a series of timely subjects, including an entire webinar on the FCRA, on student debt, student loan collection and servicing issues, fintech, post-CARES Act litigation, and others. Today's panel is myself. I'm a senior counsel with Seyfarth Shaw's Consumer Financial Services Litigation Practice Group based in the Boston office. Joining me today are two other lawyers who practice heavily in this area. We have James Billings-Kang, who's an associate in the Commercial Litigation Practice Group in our Washington, D.C. office, and also Mike Jusick, who's an associate in the Boston office and also a predominant practice in the Consumer Financial Services Litigation Practice area. Today's seminar is going to cover 3 or 4 topics on the agenda in the next slide. It's a deeper dive into the CFPB's task force and its January 2021 report that came out just before the changeover in the administration in early January. We're going to go over the background of the task force and talk about the report that it issued over the past year. Second, James is going to talk about a legal challenge that's very interesting and timely to the task force and its report and where that litigation stands and what may come of that litigation going forward. We're going to turn it over to Mike, who's going to talk about some key recommendations from the report, including the most, what we thought of its many, many, many pages and recommendations, what were the most relevant takeaways from the report. And then last, we're going to spend a few minutes on predictions for what might happen to the report. Will it just gather dust sitting on a shelf? Will it be used? Will it be used by industry? Will it be used by the new administration and the new leadership at the CFPB? We're going to try and touch on those subjects at the end. So where we start with the why, what, and when. Why did this CFPB task force get created? What did it do? And what was the timeline that it published its report? The whys really go back to 10 or 11 years ago, when we were all facing a completely different situation. The Dodd-Frank Act was passed in 2010, following the Great Recession, the financial institution set of challenges that the industry was facing following the late 2000s financial meltdown. So what did the Dodd-Frank Act do? It was congressional legislation that, among many other things, created the CFPB. And in 2012, when the CFPB came into existence, consumers were still facing high unemployment. There was record default rates on debt, mortgage loans. Consumers were reeling. And the CFPB was formed as really a super regulatory agency to regulate the financial markets, provide stability, to provide some certainty to industry participants. And really, as Senator Warren, Elizabeth Warren of Massachusetts, viewed it, was going to be a consumer-based, consumer regulatory agency that watched out for consumers. And the Dodd-Frank created the CFPB with a really unique structure. That structure was a single director, with that single director vested with great authority over the consumer financial marketplace. That single director was given a term, and under the legislation and the act, was only removable for cause. So the idea was that the director would be appointed by the president, would be in charge of executive agency functions, and with a broad range of vast functions and responsibility over consumer financial services, marketplace, products, services, the laws and regulations, regulating industry, bringing enforcement actions, providing education to consumers and whatnot. But that director would head up the agency with all of its vast powers for a term of 5 years and only be removable for cause. And that's the way things were from 2012 up through 2020. We had under the Obama administration, the first CFPB director was Richard Cordray, who was in office for all of the Obama administration and actually continued on into the Trump administration starting in 2016. When Trump came into office, Cordray ultimately resigned, moved on to a different role, and President Trump appointed first an interim or an acting director, which was Mick Mulvaney, and then ultimately Kathy Kraninger was nominated and confirmed as a full CFPB director during the Trump administration. So during Kathy Kraninger's term, which spanned from 2017 until her recent resignation in early 2021, she led the helm of this superpower agency that had control over financial consumer markets and the laws and regulations that have been passed by Congress and promulgated to regulate industry in this area. The idea, I think, for the task force was that during the Cordray-led CFPB, there was a view, especially among Republican congressional members and Republican administration members, that the CFPB was wielding its vast powers in a way that was unfriendly to industry. And the view, I think, of Kathy Kraninger was her mission was to realign the agency to balance the competing industry, the competing factors of interests of the industry versus consumers. And so in early 2020, Kathy Kraninger assembled the task force and gave it a charge. And the first thing she did in order to move this task force forward was appoint its members. And the task force consisted of 5 appointed members by Kathy Kraninger who were appointed back in early 2020. I'm going to turn it over briefly to James, who's going to talk specifically about some of or all of these five members that were appointed by Kathy Kraninger. James, do you want to tell the group about who made up the task force?
Sure. Yeah. Thanks, Patrick. So, as Patrick mentioned, the criticism of the group was that it's heavily focused on the industry and deregulation. So, the 5 appointed members by the CFPB director were Chairman Todd Zawicki, Dr. Howard Beals, Dr. Thomas Durkin, William McLeod, and Gene Noonan. In particular, as I'll get to later on in discussing a lawsuit challenging the composition of the task force, the criticism is that Chairman Zawicki, for instance, is a lobbyist for the industry and has been very critical of the CFPB. He's currently a professor at George Mason University. Dr. Beals is a professor at George Washington University, and the criticism that's been thrown at him is that he's industry focused and who's defended payday loans along with Dr. Thomas Durkin, another task force member. And Dr. Durkin, he's a retired Federal Reserve Board economist who, as I said, championed payday loans and deregulation. And the next are two partners at law firms that make up the rest of the composition of the CFPB task force. So William McLeod, he's a former FTC bureau chief. He's currently a partner at Kelly Dry. And the criticism is that he's previously supported deregulation of the industry, along with Gene Noonan, who's also a private partner at a firm. Her firm is Hudson Cook. And again, the criticism thrown at her has been that she's very heavily industry focused, despite the fact that she has served in public office for many years. She was the former head of the Farm Credit Administration for nearly a decade. So back to you, Patrick.
Thanks. So what we see is that we have a group of 5 lawyers and economists from the industry side of the consumer financial products and services marketplace, and that rankled some Democrats, and that rankled some consumer side industry participants. Task Force was launched in January of last year, 2020, with a charge to produce a consensus report within a year. That's what Kathy Kraninger asked the task force to do. On the next slide, we see that the charge consisted of 3 broad areas. One, she asked the task force to come up with an objective evaluation to her regarding the CFPB's current regulatory framework. She asked the task force to examine the legal and regulatory framework facing consumers and financial service providers, and she wanted a report of recommendations to improve and strengthen the financial laws and regulations for all market participants. It wasn't, the charge wasn't biased towards consumers or biased towards industry players. It was an objective evaluation that she wanted, yet onlookers felt that the task force itself probably was definitely geared towards industry players rather than consumer advocates. On the next slide, we see what they did. So during 2020, they obviously faced the COVID-19 pandemic like we all have, but despite the challenges faced by COVID, they conducted vast research into financial laws, regulations, the history of financial regulatory actions, enforcement actions. They held public meetings, and they interviewed many, many market participants. There were CFPB staff dedicated to help the task force, and they obviously did the background work, wrote reports, helped with the writing of the reports, and ultimately the task force completed its mission. It was directed to come up with a consensus final report by January of 2021. As we know from the November 2020 election, there was going to be a changeover in the administration once the end of January, came. And in the early January 2021, the task force completed its mission. It published a 2-volume task force report, and that's what we're here to talk about and take a deeper dive into today. So what are the 2 volumes? In the next slide, we can see what are the volumes of the task force report. The task force broke its report essentially into 2 main chapters. And the first chapter is volume 1, which is really a treatise, a very long white paper treatise. It's more than 800 pages, about 800 pages long. And it provides a lot of background, a lot of data, a lot of information, research analysis, and a write-up of justifications for a lot of the recommendations that come in volume 2 of the report. It starts with a description and discussion of consumer financial products and services, where they came from, why they solve problems, what the goals are, and government regulation of them through legislation and through regulations that are promulgated by agencies that prior to the CFPB, had been various regulatory agencies that had primary responsibility for some of the products and services and some of the regulations and laws in this consumer financial space. The Task Force Report Volume 1 contains a long discussion of the history of federal consumer law since 1968 and has a quite complete discussion of a 1970s, early 70s report that was commissioned by the executive branch in Congress that led to what's called the National Commission on Consumer Finance and a 1972 report that discusses a lot of reform in that time period, including especially whether there should be reform on interest rate caps that were in place throughout the states. It has a lot of discussion about were those caps overly consumer friendly and stifling of competition, and did they pose barriers of entry to new market participants that would provide benefits to consumers but were being stifled by regulation that was in place even as early as 1972. So Volume 1 provides really the background, the data, the research, the discussion, and justification for ultimately what the task force is recommending in its Volume 2. Its Volume 2, only 100 pages, contains 19 chapters. They're organized alphabetically, and they provide the set of recommendations that the task force made to Director Kraninger about problems facing the CFPB and market participants, what changes could be made in order to better streamline both regulation and improve the customer-facing CFPB agency, and also improve the range of products and services available to consumers from the marketplace. Some of the recommendations are very detailed and extensive. Some of the recommendations are relatively focused and limited and would be a relatively easy lift. Others of them, the more detailed and extensive of them, would require, for example, complete new rulemaking under the Administrative Procedures Act that would require notice and comment periods. Not an easy lift, not something that can be done by director mandate, not something that can be done by executive order, for example. Others of them would require a complete change in legislation. It would require congressional action. So on the next slide, as I mentioned, the task force report was issued in early January, about 2 weeks before inauguration of President Biden. It followed the changeover it preceded the soon to occur changeover from a Republican to Democratic administration in the White House. And what happened, what happened then was, so they issued the report. Kathy Kraninger is still the CFPB director, but Kathy Kraninger knew that after the Supreme Court seal of law decision, she was going to be asked to resign. Now, what is the seal of law decision, and why is it important for the task force in its report? The seal of law case, as probably most folks know, was a challenge to the CFPB single director structure that came out of the Ninth Circuit and then ultimately was decided by the Supreme Court in its 2020 term. The case arose at a California case where the CFPB had issued a CID, an investigative demand, to a collection law firm, Seal of Law. Seal of Law had refused to comply with the CID. The CFPB filed an enforcement action trying to enforce the CID in the Central District of California, seeking compliance with its CID. Seal of Law responded by challenging the CFPB single director structure and arguing that it violated the executive separation of powers in the Constitution. The trial court rejected Seal of Law's defense. The case went on appeal to the Ninth Circuit. The Ninth Circuit affirmed and rejected Seal of Law's defense. But ultimately, the the U.S. Supreme Court granted cert to take up the question of whether this single director structure that was created by Congress in the Dodd-Frank Act with vast powers over this super regulatory agency, the CFPB, with a term directorship of 5 years, only removable for cause, not removable by will, by the executive president, was that constitutional or not. And there had been prior litigation over this issue. There was a D.C. Circuit decision that originally had ruled the single director structure of the CFPB unconstitutional as a violation of separation of powers. Ultimately, the D.C. Circuit had taken that en banc and changed its mind. But the Supreme Court, in a 5-4 decision, June 2020, held that the single agency executive structure violated separation of powers, but that it didn't mean that the entire agency needed to be disbanded and thrown out. It found that the term provision for the director was severable from the rest of Dodd-Frank legislation creating the CFPB, and that simply by making the director removable at will by the president, that would solve the problem. So why does this matter? Well, it matters a lot, both for the agency going forward and also for the task force and its report, because it expanded the president's executive power to remove the CFPB's director at will. And that's exactly what President Biden did. On his inauguration day, President Biden requested that Kathy Kraninger resign. She did. President Biden appointed interim director Dave Uggio, a veteran CFPB staffer, to take the helm on an interim basis until a permanent director was nominated and then confirmed by Congress. President Biden nominated Rohit Chopra as the permanent CFPB director. Mr. Chopra is currently a Democratic-appointed Federal Trade Commissioner, one of 3 FTC commissioners. And Chopra, as on today, March 25th, 2021, he awaits a full Senate vote on his nomination to head the CFPB. He was voted out of the Senate Banking Committee earlier this month by a split 12-12 vote along party lines. So clearly the Republicans view him as too consumer-friendly. He's championed by the Democrats. Ultimately, he should get a full Senate vote. And because of the 50-50 split, his nomination is certainly in doubt. But if all Democrats were to vote for him and all Republicans were to vote against him, Vice President Harris would have the tie-breaking vote, and it's certainly possible that Mr. Chopra will ultimately take over as CFPB director after a split vote and maybe a 51-50 vote along party lines. So if that happens, what will the new director and the new leadership at the CFPB do with the task force report? That's what we're here to talk about. But before we get there, there's a really important and interesting legal challenge that may play a key role in whether that task force report really sees the light of day. And I'm going to turn it over to James to talk about the mass case challenging the task force and its report.
Great, thanks, Patrick. If we can go to the next slide. As Patrick mentioned, I'll be discussing at least one particular legal challenge to the task force and report. If we can go to the next slide. And actually, before I proceed, I will encourage our viewers and listeners to submit any questions. We will obviously turn to those questions at the end of the presentation, but we wanted to make you aware that you can submit those questions and certainly do so as we discuss these various points. So this particular legal challenge was unsurprisingly filed in federal court. The concern was, as we mentioned before, was that the composition of the CFPB task force seemed to tilt in favor of one particular voice, that voice being the industry, the voice of deregulation, to the exclusion of consumers and consumer advocates. So this particular lawsuit, National Association of Consumer Advocates against Huigio and CFPB, was filed in the U.S. District Court for the District of Massachusetts back in June 2020. The plaintiffs are two nonprofits who focus on consumer advocacy, and the remaining plaintiff is Professor Kathleen Engel, who is a professor at Suffolk University who has done extensive work in the consumer protection space. Now, the allegation hinged on one specific statute, that statute being the Federal Advisory Committee Act. I will say that that act does not have a private right of action. So what plaintiffs do, as with many other statutes that don't have private rights of action, is to use the Administrative Procedure Act as a way to challenge agency actions. So this particular act, the Federal Advisory Committee Act, what is this act? So this act is a sunshine law designed to ensure transparency in committees, in the formation of committees, to ensure uniformity of mechanisms in creating these committees, because obviously agencies, executive agencies can, if they like, avail themselves of this act to create these committees to provide guidelines and such, and provide support for the agencies. So this act requires that there be preliminary findings by the agency that the committee is essential, that it's in the public interest, and that there are no other agencies or groups that can essentially do what the advisory committee is chartered to do. And then that preliminary finding should then be reported. It should be published in the Federal Register so that the public is made aware of what exactly the committee is about, and to ensure that those preliminary findings are good on all fronts. Then a charter is filed with the agency. So here the CFPB as well as with the General Services Administration. Now the GSA is involved because it's the agency enshrined with the ability to prescribe regulatory guidelines for the advisory committee. And as I'll discuss, one of the allegations in this case is that there had been no meaningful consultation between the CFPB and GSA in creating this committee. So other requirements by the Act, well, you've got to have notice of meetings by the Act. You have to publish usually all your materials that are used by the advisory committee, or any working groups or any other subgroups within the advisory committee. And perhaps most importantly, the committee itself must be fairly balanced in terms of points of view represented and the functions to be performed. So this specific complaint had 4 causes of action, and these 3 plaintiffs alleged that the Federal Advisory Committee Act was violated in 4 ways. The first of which, it was unlawfully created because there were no, as they alleged, there were no preliminary findings published to the public, and there was no meaningful consultation with the GSA. The second cause of action was that there was a failure by this committee to publicize notices, to give the public notice that they were holding meetings, they were holding discussions, and there were no ways for the public to meaningfully assess what documents and support were used by the committee. The next cause of action, the third cause of action, was a failure, as I just mentioned, a failure to disclose committee materials. And finally, the allegation for the fourth cause of action was that the committee itself was unfairly balanced. If we can go to the next slide. And so with respect to that last point, I touched on these 5 individuals who were appointed by the director. So I won't dive into the specifics of the criticisms hurled at these individuals, but essentially, as I mentioned before, the concern was there was an exclusion of consumer advocates. Now, what's interesting is that at least recently, Jean Noonan conducted an interview with a Texas magazine, and she had mentioned that the CFPB actually offered 2 individuals who would have added to the diversity of the board. She didn't get into the specifics of what those offers were, other than to say they were for women or individuals of color, or both. and that unfortunately those two individuals had to decline the appointment for personal reasons. And she has since said that, as Jean Noonan has since said, that the public would definitely have looked upon the task force more favorably had these two individuals been appointed as well to create a 7-member task force. So along with that criticism, the fact that the composition of the board or the task force was imbalanced, also lodged against this task force was the claim that Professor Engel, one of the co-plaintiffs, she had applied for a position on the task force, but was eventually rejected. And her claim and her allegation is that there was no meaningful consideration of her application. In fact, she claims that it was sort of an inquisitorial process where they asked her about her views on deregulation and failed to ask her about her experience and background, and so there was no just adjudication of her considerations. There's also the allegation by the plaintiffs that there were meetings cloaked in secrecy. There were no notices issued about these meetings, and so again, there was no meaningful way for the plaintiffs, these nonprofits, and the professor to sort of monitor what the task force was doing and contribute to the discussions on behalf of their clients or on behalf of Professor Engel herself, who again is very much in this space. She writes a lot about consumer advocacy and speaks more broadly before many committees and before the government on these issues. And finally, the allegation was that there was a failure to provide task force materials to the public for the plaintiff's consideration. Next slide, please. And so to that end, in light of these allegations, the plaintiffs had 5 requests for relief. The first of which is to get a declaration that the task force was created unlawfully in violation of the Federal Advisory Committee Act. The second request for relief was an injunction, essentially a use injunction to set aside the task force, its charters, orders, and any decisions. The third request for relief was an injunction to prohibit the task force from meeting and conducting business. And again, I'll say that just to put this in context, this complaint was obviously filed before the task force report was released 6 months later. And then the fourth request for relief was for an order to release all task force materials, as well as the creation of a Vaughan index. Now, the Vaughan index, for those who are in the FOIA space, as you might know, is somewhat of a privilege log that agencies usually publicize. So if an agency wants to take action and avail itself of one of the exceptions to FOIA, it will issue a Vaughan index, and that Vaughan index usually provides a list of documents they wish to exclude from disclosure. The Vaughan index will also provide reasons why it should be excluded, which exception is at issue, and what interests are protected by preventing the disclosure and by using one of the exceptions. And then finally, the last request for relief was an injunction to prevent the CFPB from relying on recommendations or advice from the task force or any advice in essentially the upcoming report. So next slide, please. So the defendants, the CFPB, they filed a partial motion to dismiss, essentially a motion to dismiss the first and fourth claim. So just to remind you, the first claim again was that the task force was created unlawfully, and the fourth cause of action was that the task force was imbalanced in views and functions. And the defendants, at least in their initial briefing, in their partial motion to dismiss, specifically focused on standing. So as you probably know, there are 3 elements of standing. The 3 elements are: you have to adduce a concrete, particularized harm. The second element is to show causation. Can you attribute that harm to a specific act? And finally, redressability. So the defendants had argued that these 2 nonprofits and Professor Engel just can't show harm here, especially in in the context of the first and fourth causes of action. So there was a suggestion in the complaint that they're being harmed. The plaintiff said they're being harmed by a lack of information. And the defendants reject that argument and suggestion and almost pointedly state it's illogical. The argument, for instance, with the first cause of action, what information are you not getting by the creation of the task force, for instance? And then as to the fourth cause of action, the focus by the defendants in the partial motion to dismiss was that, well, Professor Engel, you know, you're alleging that you weren't able to get on the task force. Well, there's no right to be on the task force, so, and there's no right to get a report to your liking. So to the extent that there's some recommendation that you don't like, that is not a specific harm that can be redressed, and certainly not a specific harm that case law has provided. And so finally, even assuming there is harm, as I mentioned, the defendants are arguing, well, what is the redress here? We can try to redo the process, which would be wasteful, but that wouldn't be to the benefit of anyone. And so eventually, while mootness was not considered, so that's another argument made by the defendants. Mootness wasn't initially considered because at this point in stage of the briefings, the task force was still live. There was no report, but eventually the report is issued on January 5th, and in fact, on January 6th, the court has arguments on defendant's partial motion to dismiss. And so the concern there is, well, do we have a live case in controversy? Obviously, mootness is sort of really related to standing. It's usually the principle that at least one of the elements of standing is no longer live. Therefore, the case is moot. Therefore, the case should go away. And actually, if we can move to the next slide, and I can discuss mootness in that context. But in the mootness argument, at least from the plaintiff's view, is that, well, there is redressability here. All the standing elements are still live, despite the fact that the report has been issued, despite the fact that the task force has been disbanded. And this is because the plaintiffs now have to expend resources to study the task force, to determine whether the report has any recommendation that contravenes their goals and interests and the interests of their members. They've been deprived of information from the disbanded task force, so they still would like to review the materials that the task force relied upon, so that they then have the sort of robust, holistic set of information that the task force relied upon, so that the plaintiffs can then study that in ways to protect their members or in ways to protect themselves. And if we move to the next slide, so we get the arguments on January 6th. There's supplemental briefing after January 6th concerning mootness. And then we have Magistrate Judge Boal's February 25th ruling, which denied the plaintiff's partial motion to dismiss. And she agreed with the plaintiffs that there is standing to challenge the creation of the task force, and that they're standing to challenge the lack of balance, the composition of the task force. And that's primarily because there is informational harm that she found. The informational harm is that, again, the task force didn't provide notice or provide disclosure of their documents so that the plaintiffs can consider them eventually to monitor the task force. And Judge Boal also held that there was no meaningful, at least agreeing with the allegation, taking the allegations as true, there was no meaningful adjudication of Professor Engel's application to the task force. And that sort of goes hand in hand with the ruling that the case was moot, that still she is able, the court that is still able to issue relief that would essentially undo the harm. For instance, the relief of a use injunction, whether to prohibit the CFPB from relying on the task force, or providing a disclaimer on the report, because as it stands, agencies use these advisory committees to sort of legitimize arguments, legitimize policies. And if there's a disclaimer on the report itself, well, then the plaintiffs can use that disclaimer to sort of stifle the legitimacy of the task force report. And so I've included a quote here from Magistrate Judge Boal, which is, if the task force was in fact created unlawfully in violation of FACA requirements, then the plaintiffs have a basis for requesting a declaration that the creation and administration of the task force violated that statute and its implementing regulations, that the task force charter and all orders and decisions be set aside, and that the task force be enjoined from meeting, advising the director, or otherwise conduct business. Similarly, violations of FACA's requirements can provide a basis for enjoining the use of committee's recommendations. Next slide. So what's next? What's next as a result of this ruling? Well, the parties have agreed on briefings for motions for summary judgment, and there's potential that the court may issue a limited use injunction eventually. We'll see. We'll sort of get into that in our predictions later on in this presentation. And I will now turn it over to Mike to discuss the report's recommendations.
Thanks, James. Thanks, Patrick. If we could go on to the next slide, please. We're just going to go over briefly here today some of the recommendations within the report, as well as begin by talking about the animating principles that we kind of glean behind the report. Patrick and James talked about how the committee was made up and the criticisms of the committee being made up with what some people would see as more industry-friendly folks. Now that the report is out, I think the plaintiffs in the Massachusetts case would likely say that that their fears were borne out based on some of the language that's in the report, whereas industry folks would see this more of as an attempt to balance or perhaps refocus the Bureau away from its original conception of being a super consumer-friendly regulatory agency to one that's being more balanced in its way that it goes about accomplishing its mission to protect consumers. So we can see here one of the quotes from the report that I think pretty much shows a pretty drastic change in tone from the CFPB, or at least that's been advised to the CFPB. That the task force states that no company can expect to comply perfectly with every aspect of the myriad and often complex rules. Now, that statement was made in connection with recommendations about how the Bureau should go about its enforcement powers. But we can see just from that statement that there's a recognition from the task force that this is a highly complex area of law and regulation, and that some of the regulations are contradictory or difficult to comply with, and also raise issues with compliance with other areas of the law. As we can see going through the report, much of the language focuses on the businesses and the industries being regulated. We see discussions about cost to businesses of providing various financial services, as well as cost to businesses of studying and then complying with new regulations and activities from the Bureau. The report in many places throughout advocates that a cost-benefit analysis should be performed, and that analysis should inform, not justify, policy decisions. So we can also see through use of that language that the task force is attempting to make a split and change directions from what had come before. The task force also stated several times that it believed that the regulations that are enacted, as well as how the Bureau goes about and enforces those, should focus on areas where there's been harm to the consumer. So in other words, this task force is recommending that the CFPB not focus so much on technical violations, but should really drill down and focus in on those where a consumer has suffered specific harm. The task force also believes that focusing on harm to the consumer would be better than essentially dictating from above how businesses are to provide financial services, and that the Bureau should provide more freedom for businesses to provide their services, provided that those services don't harm the consumer. If we go on to the next slide, please. So the Bureau also, in its task force, states that consumers should be empowered through the task force believes that the Bureau itself could become a leader in financial education in the country, but to do so, the task force says that the Bureau should research first and make regulations based on how consumers actually make their decisions when they're in the marketplace. It also believes that the Bureau should go and research and see how its past educational outreach was received and whether or not it made a difference in consumer understanding. And also, one kind of new area that the task force recommended that the Bureau begin looking at was researching the economic effects of student loans, with the idea being that once the Bureau is more informed, they can decide whether and how to introduce new regulations. The task force also, as a general matter, gave quite a bit of attention to disclosures that are required in various industries. It recognized that the overall animus is that there's a thought that disclosures are helpful in and of themselves, but the task force is pointing out that disclosures may not be helpful when consumers are, and here's the quote, overwhelmed by a blizzard of information. Essentially, the idea that the task force came to was that if a consumer is trying to take out a loan or buy some other sort of financial service, and in order to do that, they're first presented with a stack of documents that they need to read through and sign. The consumers aren't going to read them, aren't going to understand what it is that's being disclosed to them, and therefore that the disclosures really aren't helpful. With respect to a cost-benefit analysis, the task force recommends that the Bureau research its past activities and look at how they impacted actual markets. And again, this is more of a change of focus to market-oriented language and business-oriented language, where the task force is recommending that the Bureau be concerned with service providers and not simply writing from the perspective of the consumer. I think the overall takeaway from here is that the approach from the task force seems to be that consumers are best protected when the regulations from the Bureau are streamlined, clear, and they're easy to comply with by service providers, and that when consumers are fully informed about and actually understand the transactions that they're engaging in or the services they're utilizing. Now, when those two things are met, that's when the Bureau or the task force appears to believe that consumers are best protected. If you go on to the next slide, please. So one of the interesting recommendations that the task force made was to look at reorganizing the Bureau. And now, just as an aside, as we mentioned at the beginning of this presentation, the Volume 2 has 100 pages of recommendations, so we're not going through every single one. There are also certain areas that the task force said were beyond the scope of its report. One example of that would be mortgage servicing. The task force, although it has some language bearing on it, it did not specifically have recommendations for mortgage servicing. We'll also be talking about fintech more in a separate webinar. But with respect to the recommendations to reorganize the Bureau, the task force came to the conclusion that some of the, or many of the Bureau's past activities had built in some inefficiencies because the Bureau was looking at the tools that it could use, in other words, enforcement, regulation, supervising, rather than focusing on the markets being regulated. So the task force recommended that the Bureau create organizations or units dedicated to certain industries such as consumer credit cards, mortgages, small dollar loans, fintech, debt collectors, and mortgage servicing, with the idea being that each of those separate units would be responsible for enforcement, rulemaking, and supervision of that particular market. Now, the report also recommend or recognize that a structure of that nature could lead to some of its own inefficiencies with various organizations and units going off and regulating in different ways. So it also recommended that a new unit, a supervisory unit, be created that would help to ensure that the Bureau is working as a whole and in a consistent direction, as well as provide objective and independent oversight of each of the unit's activities. So that would apparently require some pretty substantial reorganization. The task force also noted and acknowledged criticism that the Bureau has been undertaking regulation by enforcement in the past. The task force believed that if a reorganization along the lines that it suggests is made, that this would help to give some more certainty and make sure that enforcement and rulemaking and supervision is done in a more holistic manner. I wanted to ask Patrick too about some of the history, because there have been some reorganizations in the past. So Patrick, if you could just speak briefly about what's previously been done to reorganize the Bureau and how that might impact any future reorganizations.
Well, the short answer is that seal of law, the Supreme Court decision in 2020, affected a top-down reorganization of the structure that had been adopted by Congress in the Dodd-Frank Act. So while it's not specifically a task force recommendation, we've had a dramatic change starting in July of 2020 with regard to the directorship and how long the directorship would stay in that role. And going forward, it's clear that political considerations are going to take a much larger role in selection of the CFPB director and the policies and practice that the director takes in leading the CFPB during any particular term. We know that there's been a change already. Had seal of law not been decided the way it was, Kathy Kraninger likely would have remained in place as the CFPB director during the Biden administration, and I can assure you that the task force report would be getting much more play at the agency than it is today. So in brief, given time considerations, there are other recommendations in the task force report that may or may not be used with regard to Bureau reorganization. Only time will tell. I'm going to take a minute and just give the CLE code now. I think it's a good time for those of you who are intending to seek CLE credit. The CLE code is SS7392. To repeat, CLE code SS7392, and I'll turn it back to you, Mike, for more discussion of the report recommendations.
Great. Thanks very much, Patrick. And I'm going to attempt to be cognizant of the time remaining here. So if we could go on to the next slide, please. So the Bureau, the task force is recommending that the Bureau really consider its effects on competition. The idea here being that competition should be encouraged and will benefit consumers in the long run by lowering the cost of financial products and services. One of the quotes is that the CFPB's guiding principle is to inform use of its enforcement supervision, consumer education, research, and rulemaking is that competition should be encouraged and fostered because it benefits consumers. The task force also recommends taking into account the cost of doing business and what costs would be imposed on financial services providers every time that the CFPB implements new regulations or undertakes an enforcement action. Some of the steps to be encouraged or considered that the task force recommended is that the Bureau should look at the regulatory activity to reduce the cost of switching financial providers. The task force delved into depth about the cost to consumers of switching banking accounts or checking accounts and how that is can be a cumbersome process, and that's one area that regulations could be streamlined to help benefit consumers. The task force also looked at state licensing laws as barriers to entry. because there's often a hodgepodge or a patchwork of rules and regulations across the different states. Without endorsing adoption of the Uniform Consumer Credit Code, the task force essentially encouraged states to look at that and come up with, more holistic ways that things can be consistent across the states. Another specific recommendation was that RESPA, the Real Estate Settlement Procedures Act, should be revised to allow for packaged settlement services. Now, this is referring to services that consumers and borrowers must purchase when closing on a loan transaction, including recording fees, title fees, things of that nature. The task force concluded that consumers often don't take advantage of their statutory rights to shop around, and the theory was that that lenders should be encouraged to provide package settlement opportunities where the consumer can see one price for all of those services and pick and choose from among them. If we could go on to the next slide, please. Now, the task force also recommended that the Bureau consider allowing lenders to make more liberal use of alternative data. Alternative data referring to the use of artificial intelligence or machine learning to predict the risk of default or the risk of prepayment on any particular loan. The task force believes that it could provide a more real-time picture of cash flow, especially for consumers that have thin files or no credit files, which would include young borrowers and those that may have potentially been locked out or kept from getting loans under more traditional analyses. The goal here was that the task force believes that using alternative data could increase financial access and inclusion to traditionally underserved customers. It would not be unexpected if consumer advocates take the opposite view and are encouraging the CFPB to make sure that if alternative data is used, that it actually does help expand access to credit market and does not simply just reinforce already existing patterns. And if we could go on to the next slide, please. So the task force also had several recommendations for consumer credit reporting under the Fair Credit Reporting Act. It recommended that Regulation Z should be expanded and clarified, and that the FTC interpretations should be codified, as right now they are not seen as necessarily binding, and that having them codified would produce greater certainty. Obligations of the credit reporters, credit reporting agencies, and furnishers should be clarified. An example was given that CRAs report receiving repeated frivolous disputes, and that it's not easy for the CRAs to know exactly how they should respond and when they can respond by saying that the dispute is frivolous. The task force recommended that the Bureau should provide examples of disputes that are frivolous, and as well as how to conduct a reasonable investigation. This would potentially create safe harbors for businesses that are responding to these disputes. You want the next slide, please? The Bureau also recommended, and again, we touched on this before, that disclosures should all be looked at under various statutory schemes to make sure that they're effective and they're actually providing education to consumers. The task force warned not to confuse a consumer going through a stack of papers or clicking through a bunch of disclosures on the internet is actually providing consumer understanding. The task force also recommended that disclosures in foreign languages be developed and distributed. If we go to the next slide, please. I'll just touch briefly on this. The task force believes that the Bureau should be empowered to act quickly in times of emergencies, which it defined as a national emergency declared by the president, and that it should be able to relax certain requirements if complying with them is no longer practical because of the emergency. With respect to general enforcement behaviors, and activity. The task force recommends that consumer harm should be the lodestar. So again, as we discussed earlier, the focus should be on actual financial harm to consumers rather than technical violations of what the task force saw as complex rules. Next slide, please. And now we'll just conclude with a few predictions as to how this report may be used. One potential issue that may limit the use of the report is that it's not binding on future Bureau action. As James discussed, it's intended to inform and guide future activity, but there's nothing in the report that requires or purports to require the Bureau to engage in any particular action. As we've already seen, there's a new administration and it has a new focus. Some of the CFPB's past policy statements issued under the Trump administration have already been rescinded. Most recently, on March 11th, the Bureau announced it's rescinding a January 2020 statement of policy regarding prohibition on abusive acts or practices. And you can see from these quotes here that the CFPB is now using much more, I think, consumer-oriented language than we saw in the report. So that may be an indication that the CFPB is not really inclined to follow what had been recommended in the task force report. Finally, I think it's probably fair to say that the report's perspectives and the recommendations are likely to supply ammunition in coming policy debates from both sides. It's especially because the report's volume 1 goes through a lot of the history of consumer financial regulation and the Bureau. It'll be interesting, and maybe James has an update as to how the Massachusetts case is going, but as to whether or not that particular report would still be essentially live for debate, because that report is not purporting to provide any recommendations going forward.
Sure, yeah. So very quickly, at least in the Massachusetts case, the parties submitted a joint status report essentially outlining the proposed schedule for motions for summary judgment, which would begin in June. But interestingly, as a rationale for that particular schedule, the parties represented that this schedule will provide the parties time to engage in potential settlement discussions. So we can sort of peek into the possibility that the plaintiffs and obviously the Biden-led CFPB will perhaps engage in some sort of effort where the report is still meaningful, but in a way that also includes consumer protections and advocacy for consumer protections.
Thanks, James. Thanks, Mike. There's obviously a lot in this two-volume report. There's a lot to think about there. There's a lot to digest. There's a lot of balls in the air. We don't know whether Rohit Chopra will be confirmed or not as of today. But one thing is for sure, and that is the report has a lot of substance to it. It is going to be argued by parties on either side of the V in future litigation in terms of what should be the rule with regard to consumer financial services products and services. So we'll have to wait and see whether the report or most of it ends up collecting dust on a shelf or will really be put to use by the CFPB going forward. And there's still a third possibility, and that is that after 4 years in a Biden administration, the administration could change over again. A new Republican could come into office, and we could have a whole new leadership at the CFPB, and the task force report could be dusted off and brought back then. I want to thank all the panelists. I want to thank all the participants who joined us today. It's been interesting. The next Consumer Financial Services litigation webinar coming up in April is going to focus on the Bureau's recently promulgated debt collection regulations under the Federal Debt Collection Practices Act and a forecast for repeal or amendment under the new CFPB. Thank you again. Good afternoon. We appreciate your attendance today.